Welcome, everybody, to the Law of Self-Defense University. Today's topic will be, when can a gun be used against an unarmed attacker? Disparity of force.
Oh, there ain't no rest for the wicked. Money don't grow on trees. I got bills to pay, I got mouths to feed. There ain't nothing in this world for free. I know I can't slow down, I can't hold back, though you know I wish I could. I know there ain't no rest for the wicked until we close our eyes for good.
This is our 6th lecture. It will be podcast number 7 if you're listening to the strictly audio version of this lecture. It's prepared on September 11th, 2014. I'd like to take the next few moments in remembrance of that day. And also to remember that our work is not yet done.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Okay, back to work. The Law of Self-Defense University. When can a gun be used against an unarmed attacker? Please note, this is not an actual accredited university. And, of course, the usual disclaimers. This tutorial does not represent legal advice. It does not establish attorney-client privilege. Please do not send me any information you do not wish to be subject to a lawful demand of disclosure. Just don't. Please. Okay? Thanks. This tutorial is intended for information and entertainment purposes only. If you are in need of legal advice, please consult a competent lawyer in the relevant jurisdiction. Okay, with that out of the way, let's talk about Ferguson, Missouri, August 9th, 2014. Police officer Darren Wilson, a white man, shoots and kills 18-year-old Mike Brown, a black man. Days of protests, riots, looting, and arson follow. Now, in this tutorial, we're going to focus on just a single issue of contention. that Officer Wilson acted wrongly when he used a gun against an unarmed Brown. For purposes of this discussion, we're going to assume that Officer Wilson will seek to justify his shooting of Brown on grounds of self-defense rather than on some arrest power, which we can cover as a subject for another day if people are interested. So let's look at defensive gun use versus a quote-unquote unarmed attacker. The notion being put forth by many has been that it can never be lawfully justified to use a gun in claimed self-defense against an attacker who is not similarly armed with a gun or some other traditional deadly weapon, such as a knife or a bat. Their conclusion, then, is that because Officer Wilson did precisely this, his use of the gun was by definition excessive force and therefore cannot be lawful self-defense. If they're correct, then no other facts really matter. Wilson's use of force would be unlawful and Brown's death an unlawful killing. The question, of course, is, are they correct? So let's look at proportionality as one of the elements of self-defense. It's certainly true that one of the 5 elements of the law of self-defense is proportionality, the other elements being innocence, imminence, avoidance, and reasonableness. Proportionality essentially requires that the force used in defense must be proportional to the force against which one is acting in defense, the attacking force against you. Clearly excessive defensive force falls outside the bounds of lawful self-defense and cannot be legally justified. If the defensive force was excessive, the claim of self-defense fails. Now let's look at proportionality in the context of deadly force. And I should mention we just did a Law of Self-Defense podcast number 6, looking at the issue of proportionality in the context of non-deadly force in self-defense. So if you're interested in that, please go ahead and take a look. In fact, there's a lot more proportionality gray area in scenarios involving only non-deadly force, whereas in the context of deadly force, proportionality tends to be relatively straightforward, because what we're really talking about is deadly force versus deadly force. That is, deadly force can be used in self-defense against a deadly force attack. Deadly force used in self-defense against a mere non-deadly force attack, however, is disproportional as a matter of law, is excessive and unlawful. Anytime you use deadly force in self-defense, then, there must be evidence that you are facing a deadly force threat. Absent evidence of a deadly force threat, your use of defensive deadly force is excessive and not lawful self-defense. I'm going to give some examples of kind of randomly selected statutes on each of these issues. These are just tended to be representative of the issues we're discussing. So in this case, it's actually not a statute. It's a New Jersey jury instruction, but it addresses this point. If the defendant is attempting to protect himself or herself against exposure to death or the substantial danger of serious bodily harm, he or she may resort to the use of deadly force. So if you're facing death, deadly force, you can use deadly force in self-defense. Otherwise, the jury instruction goes on, he or she may only resort to non-deadly force. And every state has a statute or jury instruction on this point. Now, it's important to understand what we mean by deadly force. The legal definition of deadly force is not literally limited to force which can cause death. In fact, it's more broadly defined to mean a force capable or likely to cause death or grave bodily harm. Some states use the phrase serious bodily injury. There's a variety of phrases that all basically mean the same thing, serious injury to your person. Now, grave bodily harm typically includes serious but temporary injury, minor but permanent injury, maiming, loss of a bodily function, a broken bone, loss of consciousness, rape, etc. And most states have a statute which will make this clear. So if we look at representative statutes of how states define deadly force, we can see that it has this broader scope. Here's Alabama Statute 13A-3-20 defines deadly physical force as including force capable of causing death or serious physical injury. Kentucky Statute 503-010, deadly physical force, creates a substantial risk of causing death or serious physical injury. Tennessee Statute 39-11-602. Deadly force is force capable of causing death or serious bodily injury. And this is the norm across the country. Now, what do we mean by serious bodily injury? What's that actually include? Again, a few representative statutes and or jury instructions. Here's an Alaska jury instruction. 11.81.900B. Serious physical injury means physical injury that causes serious and protracted disfigurement, protracted impairment of health, protracted loss or impairment of the function of a body member or organ, or that unlawfully terminates a pregnancy. In Iowa, we have 400.16, where they define bodily injury as including serious permanent disfigurement, a bodily injury which causes protracted loss or impairment of the function of any bodily member or organ. And South Carolina, 16-11-430, great bodily injury is that which causes serious permanent disfigurement or protracted loss or impairment of the function of a bodily member or organ. Now let's talk about deadly weapons. Of course, a deadly weapon is one that can readily exert deadly force, and clearly any traditional deadly weapon, such as a gun or a knife, used in its intended manner constitutes a threat of deadly force. But in fact, any object used in a manner capable or likely to cause death or grave bodily harm represents a deadly force threat. A baseball bat used to play baseball is not a deadly weapon, but if it's used to strike someone in the head, it certainly is. A rock is perhaps the oldest deadly weapon in human history. A length of rope can clearly be used to choke somebody. A number 2 pencil, well, if you can't imagine how to cause death or grave bodily harm with a number 2 pencil, you simply don't have much imagination. A sink of water could obviously be used to drown someone. A Hello Kitty pillow, if used to smother someone, is a deadly weapon. A plastic grocery bag, perhaps the cheapest version of the Hello Kitty pillow threat. If used in a deadly manner, any of these or any object becomes a deadly weapon and represents a deadly force threat. Now, what if the attacker literally had no weapon, meaning no artificial object, external object on their person? It seems undisputed that in the Ferguson, Missouri shooting, the victim of that shooting, Mike Brown, possessed no physical weapon, no gun, no knife, no particular external object at all, which he sought to bring to bear against Officer Wilson. Does that mean that Brown was quote-unquote unarmed as a matter of law and simply unable to represent a deadly force threat to Wilson? If so, Wilson's use of his gun could not be lawful self-defense, and a shooting of Brown would be an unlawful killing. However, even an unarmed attacker is not truly unarmed in either a legal or practical sense. The legal standard is not whether the attacker possessed some object which he could bring to bear to present a deadly force threat. The legal standard is simply whether the attacker did, by reasonable perception, present a deadly force threat, by any means. An object being used as a deadly weapon can certainly provide the factual basis for this perception, but a deadly force threat can easily exist even in the absence of an object being used as a weapon. And what we're really talking about here is something called disparity of force. To determine whether a defender was reasonable in judging that they were facing a deadly force threat that justified a deadly force response, we look to see whether there existed a disparity of force favorable to the attacker that could only be met if the defender also resorted to deadly force in self-defense. Clearly, a gun-wielding attacker represents a disparity of force unless the defender also resorts to a gun or some other deadly weapon in self-defense. But there are a great many ways an attacker can present a disparity of force justifying a deadly force response even without possessing a weapon of any sort. So let's talk about some of the common situations in which a disparity of force arises. Naturally, if the attacker possesses a weapon, whether a gun, a knife, a bat, or any object that's being used in a way to cause death or grave bodily harm, the disparity of force exists. But what we're really concerned about in this lecture is where the attacker does not possess a weapon. Where can there exist a disparity of force that can justify a deadly force response for a quote-unquote unarmed attacker? Well, for one thing, is if there's more than one attacker. If there are multiple attackers and a single defender, there exists a disparity of force that no normal single person can defend against without resort to a weapon. Similarly, if the attacker is much larger or stronger than the defender, a similar disparity of force is created. The courts have long recognized that in most cases, a male attacker versus a female victim represents a disparity of force, because in the normal course of events, males tend to be larger than females. They tend to be more familiar with physical conflict than females. Of course, this is very fact sensitive. If you have a 150-pound male and a 300-pound female, the disparity of force is going to be more difficult to argue. If you have a male who is known to be of peaceful disposition and a female who is known to be of violent disposition, the disparity of force argument becomes more difficult to make. Also, if the attacker is someone of exceptional fighting ability, they're someone who's wrestled, they box, they street fight, they're an MMA, they're a karate expert, and the defender does not have a similar exceptional fighting ability, there is a disparity of force under those circumstances that can justify the defender going to a weapon when otherwise they might not be permitted to do so. It's also important to recognize that a disparity of force might not exist at the start of a fight, but can develop during the course of the fight. An attacker and defender of essentially the same size and strength may possess similar fighting ability at the start of a fight. But if the defender suffers a broken arm in the course of the fight, a disparity of force has been created that did not previously exist. That now existing disparity of force can enable the defender to make use of a weapon in self-defense where such a weapon would not have been justified previously. The bottom line, where an attacker presents a threat of death or grave bodily harm, regardless of the means, whether by weapon, other object, or simply a physical disparity of force, the defender may use deadly force in self-defense. Now, I should note, we are, of course, speaking solely on the issue of proportionality here. Any use of defensive force must also meet all the other required elements of self-defense, including innocence, imminence, avoidance, and reasonableness. Now, was there deadly disparity of force in Ferguson? To understand whether Officer Wilson could justifiably use his handgun against Mike Brown, we need to determine whether there existed a deadly disparity of force between the two men that favored Brown, the attacker, and thus justified Wilson, the defender, in resorting to deadly force in self-defense in the form of his service pistol. Based on the evidence as we know it, there were likely at least three of the classic forms of disparity of force at work in Ferguson: disparity of numbers, disparity of size and strength, disparity of fighting capabilities. Let's look at disparity of numbers first. The day after the shooting, police officials shared with the press their narrative of events. Later, much of this narrative was confirmed by Dorian Johnson, a friend of Mike Brown and his accomplice in that day's events. A key facet of that narrative is the physical confrontation began that day with Brown and Johnson as the aggressors, with both men attacking Wilson inside his patrol vehicle and attempting to seize his service pistol. Two attackers, one defender, clearly disparity of numbers. Now, it's true that Brown and Johnson had disengaged from Wilson after their initial attack, and that apparently only Brown re-engaged in his attack on Wilson, the one that resulted in Wilson shooting Brown. Throughout, however, Johnson remained in the vicinity in a position to re-engage Wilson if he chose. Wilson, having been already attacked by both Brown and Johnson working cooperatively, would have every reasonable expectation that the two men, if they were to re-engage, as Brown was doing, would do so cooperatively once again. Let's look at disparity of size and strength. Another facet of events that is simply factual and not subject to differing narratives is the size and strength of Brown and Wilson, respectively. I have not seen detailed information released on Wilson's size, but he appears to be quote-unquote normal size, for which I'll use my own height and weight as the standard, about 200 pounds, 6 foot 1 inches in height. Brown, in contrast, weighed 292 pounds and stood 6 foot 4 inches tall. I note that even a 92-pound weight difference is equal to a 5 weight class difference in Olympic wrestling. In other words, in Olympic wrestling, they would consider that a grossly unfair battle between two opponents. Clearly, there existed substantial disparity in size and strength. What about disparity in fighting ability? It's also been reported that Officer Wilson suffered a fractured orbital bone in the initial physical confrontation with Brown and Johnson. This broken bone alone is enough, of course, to indicate that Brown and Johnson brought deadly force, meaning force capable of death or grave bodily harm, against Wilson. A broken orbital bone is grave bodily harm. More to the point, a broken orbital bone would certainly have greatly reduced Wilson's ability to fight in contact again. Even if Brown and Wilson were evenly matched prior to the injury, which is doubtful given their size difference, they certainly weren't evenly matched after the bone injury. Clearly, then, there was a disparity in fighting ability that had arisen in the course of the conflict prior to Wilson turning to a service pistol and shooting Brown. Any one of those disparities of deadly force favoring Brown in his attack on Wilson would be sufficient to justify the officer in using his service pistol in necessary self-defense. This is true regardless of whether Brown possessed an artificial weapon of some kind. With arguably 3 disparities of deadly force favoring Brown, there's clearly no reasonable argument that Wilson lacked the necessary justification to go to the gun in lawful self-defense under the circumstances presented to him. Okay, folks, that wraps up the substantive portion of the lecture. If you have any questions or suggestions for future podcasts, you can always send them to me at podcast@lawofselfdefense.com. Law of Self-Defense, 2nd edition. That's the book, The Owner's Manual for Your Concealed Carry Permit. It's #1 ranked on Amazon.com in shooting category with about 90% 5-star ratings. It's available as a Kindle for about $10 or a print version for about $20, and you can get those at Amazon.com. You can also order print copies at my blog. It's about the same price as Amazon, where you can also request a custom autograph if you would like. Many people like that when they're purchasing the book for gifts. And my blog is lawofselfdefense.com. Just go to the Shop Now link. Very easy. By the way, if you're a firearms instructor or a gun store or a reseller of books, you can also buy the print book at a very substantial discount. Orders of 30 or more copies are only $10 per book. There's also the Law of Self-Defense seminars, which are held all over the country. These are 4-hour-plus state-specific seminars covering the self-defense laws of your state in detail. Where the book covers all 50 states at a high level, the seminars dig into your particular state's self-defense law, looking at the relevant statutes, jury instructions, and, most important, the court decisions, which is where the rubber meets the road, where the actual law is applied to real people in real cases. Seminars are always run with local hosts. Hosts pay nothing. They attend for free, and they generally make a little money when they host. You can look at the schedule and see what's coming up, and you can also now vote for a seminar in your area at the blog lawofselfdefense.com. If we get as few as 10 votes for a seminar in a particular area, we'll go ahead and book it and start marketing it. There are, of course, also the Law of Self-Defense University tutorials and podcasts. You just listen to such a tutorial or you listen to the podcast. You can find the video tutorials at my YouTube channel, the Law of Self-Defense YouTube channel. You can listen and subscribe to the podcast at iTunes, Stitcher, using an RSS feed, or by direct download from my blog, lawofselfdefense.com. As I've mentioned, all these tutorials, the video tutorials, are also presented as podcasts. In addition, we also do a number of podcasts that are solely podcasts that don't appear as tutorials, usually when we're covering some kind of self-defense news in nature. And as always, suggestions for tutorials and podcasts can be sent to podcast@lawofselfdefense.com. Okay, thanks for attending Law of Self-Defense University. Stay safe, stay prepared, know the law. Class dismissed.